Good morning, Mr. Foley.
Good morning, Your Honors. May it please the Court. Thank you for the opportunity to be here this morning. My name is Thomas Foley. I represent Matt Zubiel.
Do you agree, Mr. Foley, that if these words had been reduced to some typewritten piece of paper or handwritten, same words, and sent, that the statute would have been violated?
If they were handwritten, it would have been violated. Yes.
Or typewritten?
Or printed on paper. Yes.
Typewritten such that they were imprinted on a piece of paper, printed on a computer printer, or...
Yes, printed on some sort of paper, yes. That's important for the definition of print that we learned from O'Keefe.
So what if someone took a pornographic photograph, scanned it, so it converted it into electronic form, and then disseminated that to a young person? Would that be a visual representation?
Yes, it would, Your Honor.
What if it was a pornographic book that was scanned and sent? How about that?
If the book contained visual representations, such as
just
pictures,
words, just a
words, then
pornographic novel.
Well, scanned, that's an interesting question because it is printed on the book.
But
the book is scanned. Well, that's an interesting question. We don't have that interesting question. I think that's one that maybe you'd have some room to play with under the definitions, and maybe you would hold in that case that that was matter under the statute.
What if the facts were that the alleged victim of this crime printed out an email or an instant message, as happened with the?
I think you'd have problems finding a defendant guilty under that scenario because it's not the defendant who's sending out any print. It's the victim who prints it out. So what the defendant did was disseminated computer-generated writings. He didn't disseminate anything printed. So I think under that scenario, that would not be dissemination of matter harmful to a minor under the definition as it stands now. And yes, sir.
Do we know? Do we have any insight into what the legislative intent was regarding this situation?
Well, regarding
whether
use
or
of
not
computers with text?
Yeah.
What we do, Your Honor, because in, I believe it was 2000, the state Senate considered a bill that would amend the statute. It was after the O'Keefe decision, so they were looking at the language because they were going to amend it to include handwritten materials. So they considered amending the statute to read handwritten, typed, or computer-generated writings or images, whether printed or electronically transmitted. Now, had they amended the statute that way, then I wouldn't be here right now. My defendant would be guilty under the statute. But they didn't do it. Not only did they not amend the statute, now here we are 9 years later, but as the members of the Joint Committee on Criminal Justice recognized when considering that Senate amendment, they stated that amending the statute to include the controversial language relative to Internet and other computer transactions may implicate constitutional protections. And I think we have to respect that. They realize that there are going to be some special matters that are going to have to be looked into if a statute is going to be extended to apply to computer-generated text. You've got Commerce Clause implications. You've got free speech implications. You've got overbreath. And it's not as easy as just
Mr.
saying...
Foley, I understand your argument. I would say just two things. One is, you know, there's a whole body of law that says when the legislature fails to act, we don't take that as indicative of intent, leaving that aside. But why would the claims that you have, you know, the Commerce Clause, the First Amendment Clause, and so on and so forth, why would that implicate electronic messages any more than paper messages?
Well, first of all, when you're on the computer, when you're on a chat board, you don't really know who you're chatting with. Somebody
Doesn't make any difference, does it?
Pardon me?
It doesn't make any difference, does it?
Well, it does for overbreath.
Okay. So overbreath, I understand,
Sure.
but for okay.
For Commerce Clause purposes, you've got the fact that these Internet messages, these online communications, are going across state lines and country lines.
Was the definition of visual material amended in 2000? I mean, when did that language get into the visual material definition?
That was either 2000 or 2002.
I mean, was it part of the same
amendment that you say that the legislature didn't put computer-generated into this particular?
I believe that they were looking, after the O'Keefe decision, they started looking at a lot of these things, and these amendments came out either in 2000 or 2002, and I think
They
they're
were
all
part of one package.
I think they're all part of one big conversation in the legislature on how to update these statutes. They didn't amend the definition of matter to include depiction by computer.
Right, now I understand that.
Yes, and again, they didn't. The reason they didn't do is because they realized that it may implicate constitutional protections. And you know, I didn't raise a constitutional issue. We could debate the constitutionality of computer-generated messages going over the internet, whether they do or do not violate the Constitution. But that's really not the issue. The issue is that the legislature thinks that they might, and we know that that's why it wasn't amended.
Some people in the legislature
Well, the
might.
Joint Committee on Criminal Justice, it's going to make the recommendation, and they never did, in fact, amend the statute. And you know, I think we have to respect that, although on the other hand, I'm a parent, I've got 2 girls, and I don't want this sort of thing to happen to my girls. I think the statute should be amended, but I think it has to be done carefully. I think the legislature has to do it to make sure they don't run afoul of the Commerce Clause, the First Amendment, that they don't make it overly broad. I don't think that just in this court today deciding that we're going to pigeonhole computer-generated text into visual representations is not the way to do it. I mean,
at trial, what was the defendant convicted of? Was he convicted of disseminating to a minor any matter harmful to minors?
that's correct, Your Honor.
But the person who received it was not a minor.
No, and there were a lot of issues. That was all debated and argued pre-trial, and I elected not to raise that issue. That was an interesting issue, but I think the fact that he believed it was a minor was going to be enough to get him into trouble in this case.
All right. Now, would your argument differ, or would our analysis differ, if he was convicted of the other prong, which is to have in his possession any such matter with intent to disseminate to a minor? I mean, how do you have an IM an IM message in your possession? How would that
I'm not
work?
sure how that even. I don't IM myself, but so I don't know if you could type an IM on your computer and have it sit there ready to be sent. Maybe you can, but in any case, it would be on your computer. I think under the matter statute, since it wasn't disseminated. Well, I don't know how you'd prove intent to disseminate there. I think you'd have to prove the intent to disseminate. It would all depend on the evidence that he was intending to disseminate it to a minor. But then you'd still have this problem of the electronically communicated text. But, you know, we can go round and round on the constitutionality and what the legislature's purpose was in not amending this statute. But I think really what it comes down to is fairness. The statute would be vague if you suddenly, especially after the O'Keefe decision, when you say handwriting is not a visual representation, how can computer-generated text be a visual representation?
Is that what O'Keefe said, that handwriting is not a visual
Well,
representation?
in O'Keefe, it was before the statute was amended to include handwriting. So
Right.
in O'Keefe, we had handwriting and
We said handwriting, or the appeals court said handwriting is not
it's
printed
not
matter.
print. Now, what's
Also-
interesting is they never even considered handwriting as a visual representation because we all know what a visual representation is.
Well, give me your best case as to why this material that was electronically sent to a screen where it could be visually represented, so to speak, why it is not a visual representation.
My best case is the fact that there's no case that says a visual representation can be words. And it's just not. Visual representation has always been in every statute. I've Googled and I've Westlawed every time visual representation has come up, and I've never once seen it used to define something as words. It's always pictures. If I hold this folder up and I announce to this court that in this folder I have visual representations of child pornography or visual representations of matter harmful to a minor, I suspect now one person in this courtroom thinks that I've got a folder full of pages with words on it. They think I've got pictures. They think I've got sketches, maybe a DVD with photographs on it. Visual representations are not known by the common man, by a reasonable man, to refer to words.
So you say that the computer screen is the equivalent of a piece of paper. It's got printed matter on it.
Well, it's not printed because
No, but I mean,
that would run afoul.
it's got words on it, so
It's
it's,
got
so
words.
it's disingenuous to say it's a visual representation. That would be
Yes,
your
Your
argument.
Honor. It is, visual representation has never been used to define, to refer to words.
So if you're right, if you prevail, that means that anyone who wants to can engage in any kind of talk with other people using whatever language they want to without violating the statute.
Without violating this statute. There
As
may
long
be
as they
other-
don't
yes.
print it out or fax it. If they faxed it, that would be a violation.
I would think that would be a violation. That's printed matter, yes. Yes, I think that that's where we stand now. And there may be federal statutes that cover it. There may be other mass statutes that a defendant doing this sort of thing could run afoul of. But as far as this statute, yes, people can do this now in Massachusetts. They can instant message young girls this kind of harmful matter. And I don't like it. Like I said, I've got 2 daughters. But unless you're gonna make visual representation include words, something that no court or maybe no person has ever done before, that's where we stand right now. And
Well, the legislature can always amend the statute.
I think they should. I think they should have back in 2000 or 2002, but they got scared apparently by these constitutional implications, and they didn't get around to it. And I don't know why. I think if I do win this case, I certainly hope you issue a decision that stresses that it's about time that they do something about it.
We
And
don't do policy, Mr. Foley.
Well, I think in O'Keefe, the message was if the legislature wants to amend it,
No,
they
we've
know how
said
to
that
do it.
before, but I mean, there may be, it's not for us to decide, where the line drawing is. I don't think when you have a statute at issue, we can do it under the common law, but this is a statute here.
I understand. But it is troubling. I don't like it, but yes, that is the law now.
Now, would voicemail messages qualify as sound recording? Voicemail messages.
I would think so.
And you can actually communicate sound through computers now, can you not?
Yeah, yes, you can.
So
I
if
don't, but
this
I believe-
electronic message had some sound attached to it, sort of essentially repeating what is written in some verbal way. That might.
I think you'd be able to find a sound recording under that situation. I think this is a pretty unique situation, or this is falling through the cracks of the statute. These instant messages, these computer generated, and email came up below. They were talking about, the Commonwealth expert was talking about the difference between email and instant message, and well, these are online communications, these instant messages, but email goes to different servers, so that's not exactly the same. Problem is, I think even under email right now, that they wouldn't fall within this statute.
Yeah, why would email?
I don't think it would.
instant
I don't think it
messages
would.
don't-
I don't
why
think
would
the
email?
fact that it goes to different servers really makes any difference. It's still electronically communicated.
And instant messages, they go through servers as well.
The expert made it sound like it went computer to computer.
You think that's right?
I-
You don't think? I mean, they met through a chat room and then they sort of. Well, I don't know.
I don't
And
even
if-
really know what a server is.
If the kid, if somebody prints up the email, does it become printed material?
Well, again, that was Justice Botsford's question. It depends on who prints it. If the victim prints it, I think a defendant has an argument that he didn't send any printed material. I sent computer-generated text. She turned it into printed material. Now, so I think that the defendant would have an argument that that is not printed material and that would not fall under the statute. But that's another case. I don't know. There's a little more wiggle room there. But in this case, where it wasn't printed out, you've just got the direct online communication. And I think that's one other thing to keep in mind as my time's running out. Remember that the statute disseminating matter harmful to a minor does not prevent anybody from having conversations with a minor. And really, we're talking about, there was a lot of talk in the Commonwealth's brief about, today's day and age with all of the communication updates. And I think in today's day and age, more conversations are being held online than maybe in person to person. I think these online communications are probably closer to conversations people used to have than they are to emails that were used or even letters being sent. These people, if you read the conversation, they're talking back and forth, and it's instantaneous. So, I think the fact that the statute doesn't outlaw conversations, and this is really a modern-day conversation, lends further support to my argument that the legislature has to date not address the problem of how to regulate these internet online communications. They're not visual representations. If there were photographs or photographs attached, then I wouldn't be here. But the truth is, nobody refers to visual representations as words. Visual representations are pictures, and these words on this computer screen are not pictures.
Thank you, Mr.
Thank you,
Foley.
Your Honors.
Good morning, Ms. Fleeman.
Good morning, Your Honors. Kristen Freeman on behalf of the Commonwealth. If I could just leave off where, or start where defense counsel left off with regards to it not being visual representation, I would suggest to the court that the type depictions of the words on the computer screen are very much visual representation.
What's the case that says that?
Unfortunately, we don't have a case.
Anywhere in the country?
I don't have one.
Ms. Freeman, would you say that a piece of paper, I forget the fact that statute reaches printed material, but a piece of paper with words printed on it, is that any different in terms of the visual representation than a computer screen with words depicted on it?
I would say that that printed material could also be considered visual representation. Where you see it, it's something that's represented on a piece of paper, very much like a computer screen. So I would say that even printed material falls under the category of visual.
Why do you need anything else? I mean, just use visual representation, since you seem to include absolutely everything in it.
Well,
Except
for
for sound.
purposes,
Is this a visual representation?
I would say that it is.
Well, then don't we have to give meaning to every word? So what do we then do with the rest of the statute, as Justice Botsford is suggesting?
Well, I think the rest of the statute has the 4 different examples. I think that they spelled out handwritten or printed material just to clarify with regards.
All of which would be visual representations under your theory.
I would suggest that it could fall under that theory, correct. But the other 2 categories that are spelled out, live performance, sound recording, or
So I
especially
take it
sound
this is a jury waived trial. So in a jury trial, the judge instructs anything that appears on a screen, anything that appears on a piece of paper, anything that appears on the side of a box, anything appears anywhere in the world is visual representation.
You can see it. It's a visual representation.
Well, I would suggest to some extent, I mean, I would have to know specifically what,
Oh, anything that appears on a screen, anything that appears on a piece of paper, anything that appears essentially anywhere is a visual representation.
I would suggest
Well, then
that
why
it
don't we
is.
just ban the content? Why don't we just say you can't engage in this conduct?
Why wouldn't we say that?
Yeah, we just say any communication, that is, and then you get into the definition of obscenity.
Well, I think that's the purpose of the statute, and I think
But
if
that's
you
not
look
what
at
the
this,
statute says.
Well, for matter, and just by analogy to incorporate the other statutes, the dissemination of child pornography, the possession of child pornography, the broadest terms, I would suggest, are represented by matter. And when you look at the other definitions in the other statute for dissemination of child pornography, a visual material. And if the intent of the statute was to just include images that were on a computer screen, I would suggest that the language for dissemination of matter harmful to minors would have said visual material, and that clearly incorporates images. And I think they meant to be more broad in the dissemination of matter harmful to a minor, so they use the term matter with 4 broad categories and a list of examples. And I think it's important that they said including but not limited to. It's just left open-ended.
Don't you have a vagueness problem? I mean, your argument really will take in everything. Isn't there a vagueness problem if you're a defendant trying to figure out, if you're a person trying to figure out what's legal and what's not legal to do, how would you get any guidance from the way you are interpreting this statute?
Well, I would suggest for purposes of right now, I would say that definitely type depictions on a computer screen do qualify as visual representation. And what's interesting is in the chats that were introduced into evidence during the course of the trial, and they're in the addendum to defense counsel's brief, and it's specifically on page 32, the defendant himself says, we can get in trouble for what we talk about us fooling around and stuff.
You know,
Well,
You can get in trouble. This is this is an older man speaking to someone who's, what, 13 years old about having sex, I assume, and getting together to have sex, I assume that's a fair statement that we could get in trouble for this.
Right, but I guess my point with that is that it's not vague in so much as even the defendant himself recognizes.
If he engages in any conduct, he will get into trouble.
Right, but he says what we talk about, which I thought was interesting because
But you're not telling me that the statute says that if you have a conversation, that violates this statute?
on the type
No.
Conversation.
He has a conversation. He goes to the street and he sees a 13-year-old, and he says exactly the same thing to her.
Right. I would suggest no. I don't think it's covered under the statute, under any of those four broad terms that are listed under matter. Conversation is unfortunately not one of them.
Let me ask you this. If this defendant had been an attorney and had said, I'd looked at the statute and I think this conduct falls outside, would your argument be different?
It wouldn't. I would suggest that.
So it doesn't really matter whether he thinks it's going to be a crime. It matters whether it is a crime.
Right. I guess for purposes of ambiguity.
Well, I mean, in terms of ambiguity, if you were to go on the street and ask 20 people what a visual representation is, do you think you would win in this particular election, or do you think Mr.
not.
Foley would probably have the better view?
Probably not.
Well, then how do you get past triplet?
I'm sorry?
Then how do you get past triplet, Commonwealth against triplet, that says, it's what ordinary people can understand? If you've just conceded to Justice Gantz that you wouldn't win, probably not. I mean, isn't that the test?
Well, I would suggest that everybody's interpretation would be different. However,
But doesn't that fail the test almost by definition?
I would suggest no.
Why? That's our law.
Doesn't there have to be a common understanding?
And I think there would with regards to this particular case. I think the text on a computer screen, when in this day and age, when that's how people communicate, the way...
What would be helpful to me, and maybe this is asking too much, to say, look, the only way this conviction can be upheld is if you hold that text on a screen is visual representation. I recognize it's a stretch. I think you can look at legislative intent. I think you can overlook the failed 2000 amendment for all the reasons that we cite. Other than that, I don't have to belabor the point that ordinary people probably would not think that visual representation included text on the screen. Wouldn't that be a pretty straightforward case? And either we agree with you or we don't agree with you.
I would suggest that there are people, many people, who would suggest that text written on the computer screen would qualify as visual representation. I think that that's something...
We don't have any way of testing that.
No, and we don't. But I would suggest, based on the case law, there's none directly on point with regards to...
But doesn't that tell us something? Doesn't that tell us
there's no
something?
case law?
Yes. I mean, instant messaging has been around for quite a long time. Quite a long time. Everybody recognized that there should be that in order to cover this, at least some people in the legislature recognize that they should amend the statute.
I think it hasn't been tested before. This is a novel issue, and perhaps it hasn't been tested because people have realized that the text on the computer screen is something that falls under the definition of matter. And the most recent cases I can find with regards to even the other the statutes, the dissemination of child pornography, the possession of child pornography, is Perry versus Commonwealth for dissemination of child pornography, which held that visual material included computer images.
That's not a problem.
No, I know, but I guess my point is that it seems like the cases have all been trying to generally protect children from sexual exploitation and abuse, and I would suggest that...
But, we don't try to do things. We try to interpret statutes, right? A computer-generated image, your word, falls, it would seem to me, under a visual representation because it was a picture. The fact that it was computer-generated wouldn't make much difference.
Well, I would just suggest in those line of cases, it seems like they're incorporating the computer images.
Yes, of course we incorporated computer images, because an image is an image is an image.
But with regards to this particular statute, I would say that it's appropriate for computer type depictions on a computer screen would qualify as the visual representation, that would further the intent of the legislature to protect children from sexual exploitation.
Would it qualify as visual material?
I would say that it would not.
Because it's not,
Because it's not pictorial.
Correct.
And in the context of visual material, they use the word similar visual representations as a catch-all, essentially, or other pictorial.
Correct. And I would say with regards to that, the way the statute is constructed there, or similar visual representations, it does, I would suggest, limit it to something that's a picture. But then the statute was amended to add depiction by computer.
But isn't it the same meaning in matter? Visual representations. It's sort of like the cartoon or a handwritten sketch, something other than a picture or a photograph.
Right. And I would say
It doesn't mean textual, it means pictorial.
in visual material, I would say yes, that's absolutely.
What about in matter? Why
Correct.
isn't it the same meaning?
same phrase.
It's the same phrase. However, the way it's constructed in the visual material, it's the way it's constructed when they have it, any motion picture, film picture, photograph, videotape, book, magazine, pamphlet that contains pictures, photos, or similar visual representations.
Well, but they're all jumbled up there. There's pamphlets is in the middle. It doesn't follow handwritten or printed material. It's in between picture films and phonographic records.
Right, but I would still suggest that even though it lists all those things, or in the way it's worded at the end, or similar visual representations, it means similar to the things before it. But in the matter statute, it just says any visual representation. It's not or similar visual representation such as they have. They list the 4 broad categories within an open-ended list of including but not limited to, and they even have plays, dances, figures, statues. They have just an open-ended list that's not limited to what they have listed there. So I would say it's not similar to the term visual representation in the dissemination of child pornography statute. And I would suggest that if it was meant that it was just supposed to be pictorial, things of that nature, that matter would have used visual material as opposed to visual representation. I think that they purposefully used that term to incorporate the text on a computer screen.
But the funny thing is it uses the same matter, uses many of the same words as visual material does. It uses pictures, photographs, visual representations, book, magazine, pamphlet. It uses all the same terms.
Mm-hmm. But just the way it's constructed with regards to the visual material, I would say that it's different because of the way it's constructed under the dissemination of the child pornography statute.
Thank you, Ms. Freeman.
Thank you.